Hi, I'm Mike Lee, author of Our Lost Constitution. I wanted to take a few minutes today and talk about the Second Amendment. In a prior episode, we discussed some of the early origins of the Second Amendment. We may discuss that briefly today, but I wanted to tell you a story today to explain what happened to the Second Amendment prior to its reinvigoration just a few years ago with a Supreme Court ruling in a case called the United States versus Heller, decided in 2008. What had happened to it? Where did it go? To open that story, I want to tell a story about late Chief Justice Warren Burger. After leaving the bench and no longer serving as Chief Justice in 1986, about 5 years after that, in 1991, Chief Justice Burger spoke about the Second Amendment in terms that were rather inflammatory, and in fact, in terms that were just blatantly false. He referred to the Second Amendment, to the notion that the Second Amendment provides an individual right, as a great fraud, one of the greatest frauds that's been perpetrated on the American people. Presumably, he was speaking out against gun rights organizations like the National Association for Gun Rights, the NRA, and so forth, although he didn't mention them individually. But in saying this, he was echoing an ignorance that had been prevailing in the federal court system for some time. It's disappointing that Chief Justice Burger, himself having served on the highest court in our land as its Chief Justice, would be so brazen and so mistaken in making a statement like this about the Second Amendment. But I thought in this episode we might discuss a little bit about how he got there, why he thought that, and why that reflected in some ways a prevailing viewpoint at the time, as wrong as it was. If we go back to the 1930s, we discover an interesting case that came before the Supreme Court. It involved a defendant named Jack Miller. Jack Miller was caught with a sawed-off shotgun, and he hadn't paid a special tax that Congress had imposed on that type of weapon. Jack Miller was not a good guy. He was involved in a lot of bad things, but he was charged with this offense. And for reasons that aren't entirely clear from the record, the district judge assigned to his case in Arkansas was a federal district judge named Hiram Reagan. Hiram Reagan, prior to becoming a federal district judge, had served in the United States Congress during the 1920s. By the 1930s, when Jack Miller's case came along, he would have certainly described himself as a New Deal Democrat, but if he were alive today, he probably would say that he was a New Deal Democrat before there was a New Deal, before FDR ever even came along. Hiram Reagan, when he had served in the U.S. House of Representatives, was an aggressively anti-gun rights congressman. In fact, he had introduced legislation basically just trying to dramatically weaken gun rights. And he had expressed opposition to anyone's right to own all pistols whatsoever, as he put it. So when he became a federal district judge, I believe having been appointed to the court by Franklin D. Roosevelt, this mindset lingered with him. This was still part of who he was. Hiram Reagan was still at his core, this same guy who had introduced this aggressively restrictive gun legislation. He was the big gun control fanatic of his time in the 1920s when he had served in Congress. But this was still with him. Along came this case involving this defendant named Jack Miller, who had possessed unlawfully a sawed-off shotgun, not having paid an applicable federal tax on that sawed-off shotgun. For some reason, Hiram Reagan decided, without any prompting by anyone, I don't think it was raised by Jack Miller or his attorney, Hiram Reagan just decided to raise this issue on his own, to ask the parties to brief the issue, and eventually Judge Hiram Reagan issued an opinion concluding that this law that Jack Miller had broken was unconstitutional for the simple reason that it violated the Second Amendment. Significantly, however, Judge Hiram Reagan didn't explain his opinion. He didn't explain his ruling. He basically left it there. It was just what we call an ipse dixit ruling. It is this way because it is, because I say it is. And he left it at that. Looking back, And knowing Hiram Reagan's background, I think that what he was really doing was trying to get this teed up before the Supreme Court. He knew that at the time, a federal judge who struck down as invalid, or at least who invalidated the application of a federal law to a particular case, was very likely to make that case appear in front of the U.S. Supreme Court. And I think that's what he was trying to do. I think Hiram Reagan had as his design getting this case in front of the Supreme Court so that the Supreme Court would actually weaken and undermine the Second Amendment, because Hiram Reagan hated the Second Amendment. He was a big fanatic for gun control. That's what he wanted. So that's why he was willing to issue this opinion with basically no reasoning, basically no analysis, no justification. Meanwhile, the case went up to the U.S. Supreme Court. Like I say, it was very common at that time. Anytime a federal district judge invalidated a federal statute, that was very likely to occur, and it certainly did occur in that case. When it got in front of the U.S. Supreme Court, the federal government was appealing this ruling, asking for the court to undo Judge Reagan's conclusion that the Second Amendment invalidated this law that Jack Miller had allegedly broken. When it got in front of the Supreme Court, Jack Miller's lawyers were nowhere to be found. They didn't file a brief. And in fact, in the end, Jack Miller's lawyer just sent a telegram to the Supreme Court basically saying, I'm not going to file a brief in this case. So there was no attempt made to defend Judge Hiram Reagan's decision, his ruling that that this firearms law at the federal level was unconstitutional under the Second Amendment. And Jack Miller's own lawyer didn't even file a brief in that case. And so there was no one there to defend it. In another stroke of bad luck, the task of writing the opinion in that case got sent to Justice James McReynolds. Justice McReynolds is one of the most reviled characters in Supreme Court history. This man was a bigot. He was a bigot who hated racial minorities, who hated anyone who... And as a result of this, he was not liked, still is not liked, among those who study the Supreme Court. And he was certainly not known as an intellectual powerhouse on the court. Justice McReynolds got assigned to write the opinion in this case. And he has this meandering opinion that makes basically no sense. But ultimately, he reverses Judge Hiram Reagan's decision invalidating this law under the Second Amendment. And Justice McReynolds does so in this opinion involving, called the United States versus Miller, issued in 1939. Justice McReynolds' opinion in United States versus versus Miller says basically that this particular gun cannot possibly be said to be protected by the Second Amendment. Certainly it doesn't apply here. And that was about the extent of it. He went into some reasons why a sawed-off shotgun shouldn't be protected by the Second Amendment, but there wasn't a whole lot of analysis. What happened then was that opinion was issued, written by Justice McReynolds, issued by the Supreme Court of the United States in 1939. For decades after that, I mean, we're talking about a period of nearly 70 years, the Second Amendment was basically assumed to be a Nothingburger. It was essentially assumed not to really do anything to protect gun rights. And that's one of the reasons why Chief Justice Burger in 1991 was willing to make this statement, this absurd and absurdly wrong statement to the effect that the Second Amendment doesn't really do anything, that it doesn't actually provide an individual right. He was wrong, but he was assuming a whole lot of things that had been mistakenly assumed by federal judges, mistakenly taught by law professors, because people just assumed it was a dead-letter law. This is a great example of why it is that we shouldn't look at Supreme Court precedent as telling us exactly what the Constitution says, what it means. Sometimes things happen at the Supreme Court that result in an issue not being squarely, properly presented to the Supreme Court of the United States. Sometimes issues like these are never properly brought before the court, and sometimes when they are, they're brought forward in a case that was inadequately briefed or something. And that's why people shouldn't cease to assert a right simply because a right seems to have been weakened by the Supreme Court, or simply because the Supreme Court has been unwilling itself to defend and vindicate and assert that right. We have to be willing ourselves to know the history behind it. Well, let's fast forward a few years. more than a decade passed after Chief Justice Burger's statement was made, which itself was made many decades after the Supreme Court issued that horrible decision in United States versus Miller. And in the early 2000s, there were a few people in the District of Columbia who started realizing, we've got a high crime rate in the District of Columbia, and we also have some of the most aggressive, restrictive gun laws in the entire country. Perhaps it's time to start asserting the Second Amendment. And a few people got together, and eventually there was one man named Dick Heller who decided to challenge that law. He lived in a high-crime neighborhood within Washington, D.C. He, by day, was a law enforcement officer and had a gun. But as a private citizen, he was not allowed to possess or wield that gun in his own defense. And yet he lived in a neighborhood where bullets seemed to be flying left and right. In fact, one bullet actually made its way, literally, to Dick Heller's door. And yet, under District of Columbia law, he was not allowed to have a gun. And he thought about this, and eventually he decided that he needed to challenge it. He went down and actually applied for a permit to have a gun so that he could defend himself. That was, of course, denied. He ended up challenging the D.C. law, and it made its way all the way to the Supreme Court of the United States. And in 2008, in a case called United States versus Heller, the Supreme Court recognized what had always been the case, but a fact that had been largely ignored ever since the Supreme Court issued that ill-fated decision in United States versus Miller in 1939. Namely, they recognized that the Second Amendment, in fact, does provide a right. It's an individual right, a fundamental right, a constitutional right. And it's a right that doesn't attach simply to the right to form a militia that the people have collectively. It is an individual right, and Dick Heller had that right. This was remarkable. Not always does it work this way. I wish it would happen more often this way, but sometimes once a constitutional right has been neglected for that long, the neglect sort of ossifies to the point that people no longer think they can assert a particular right, and the protection at issue kind of dies. But this is a great example of how we shouldn't give up, even how decades after something has been neglected, even after someone who had previously served as the Chief Justice of the United States Supreme Court denigrated that particular right. It was still able to be exercised in the Heller case, and it was exercised successfully. Now, of course, the Heller decision was on solid footing because the Second Amendment itself does, by its own plain language, protect a fundamental constitutional individual right. And in fact, this right goes back a really long time. I mean, it goes back to a time before we were even our own country. To fully understand the Second Amendment, it's important for us to go back to the late 1600s. During the reign of King Charles II, Charles II didn't want to find a similar fate as his father had found, where his father had his head cut off. He was really worried about maintaining his tight grip over the citizenry throughout Great Britain. And so he put through legislation dramatically restricting the right of citizens to bear arms, to have weapons for hunting and for self-defense. This tradition was unfortunately continued under the reign of James II after Charles II. And in fact, James II made it even worse. He adopted this policy of very aggressively searching firearms and seizing them when they were in violation of laws put in place by Charles II. By 1688, Englishmen had finally had enough, and they were able to overthrow James II and replace him with an heir, one of the heirs of James II, his daughter Mary, and her Dutch husband William. This is an event in English history that is known as the Glorious Revolution of 1688. And it was in connection with that Glorious Revolution of 1688 that many of the fundamental rights of Englishmen were put in place under a Bill of Rights put forward and advanced and defended by William and Mary. Among those rights was the right to bear arms. Now, the right to bear arms as put in place under the reign of William and Mary really recognized that this was a fundamental individual right, that people had the right for hunting, and they had the right for their own defense, their own self-defense, to bear arms. And this was echoed in the Federalist Papers by Alexander Hamilton, who wrote that the original right of self-defense is paramount to all positive forms of government. So keep in mind, Hamilton wrote that at a time after the Constitution's drafting, but prior to its ratification, and certainly prior to the adoption of the Second Amendment in 1791. And he was just recognizing that this was a pre-existing individual fundamental right of British subjects. It was already there. And so what they were recognizing was something that people already had in this country as British subjects. They were extending a right that had already been recognized as far back as 1688 during the reign of William and Mary. It's very important that we remember this, that we remember these stories when we talk about our Second Amendment rights, because these aren't new. These aren't things that have simply been fashioned by some powerful interest group or a group of gun manufacturers in modern times for modern convenience. No, this is fundamental. This goes back many, many centuries. It goes back to a time long before we flew the Stars and Stripes, when we were still flying the Union Jack. This was in place. These are our rights, and they can't be taken away from us. It's one of the reasons why every time I'm faced with gun control legislation, I look at it very carefully. I look at it very carefully with the understanding that the right to bear arms is a significant one, and it's not one that can be neglected. It's not one that can be taken lightly. You know, what's interesting is that more often than not, when I really look into a particular piece of legislation that's put forward in the name of gun control for the sake, ostensibly, of advancing public safety, most of the time, basically all the time, certainly more often than not, that legislation would do little or nothing to deter criminals from engaging in criminal activity. And it would do a whole lot to restrict the rights of law-abiding American citizens who just want to use firearms for their own lawful purposes. That's one of the filters that I apply, and I certainly remember and take into account our long history of protecting the Second Amendment's right to bear arms, which itself far predates even the Second Amendment and even the Constitution and even this great country. So thanks very much for joining us today. And please, if you're interested in more of these, please like this page and follow this page. And that will make sure that you're able to receive more of these video posts. If you'd like to learn more about our lost Constitution, please feel free to borrow it from a friend or check it out from a library, or if, when all else fails, you could even buy it. It's available on Amazon, Barnes & Noble, and elsewhere where books are sold. But I'd love to have you take a look at it. Let me know what you think. You can comment online at our Lost Constitution Facebook page. Thank you very much.